Withholding of removal, a mandatory form of relief in immigration removal proceedings. In this video, I am going to talk about withholding of removal and how you can make your case in court in absence of showing the well-founded fear of past persecution or the well-founded fear of future persecution. My name is Bijoux, Ngwanda. I'm an immigration lawyer based here in DC. I work with individuals across the country and around the world because we're dealing with complex U.S. immigration law cases. If you're new to my channel, please go ahead and subscribe. If you're not new, welcome back. Thank you for subscribing. And please do not forget to hit the notification bell so you do not miss anything. If you enjoy the content, please go ahead and share, like, and don't forget to comment below. Also follow me on Instagram, where I talk about immigration employment base, the business side of immigration. I'm talking about self-petitioning. I'm talking about employment-based immigration, investment, and more. Let's get right into the subject: withholding of removal. It is a mandatory relief, which simply means that once you fail to establish asylum, right, you can ask for withholding of removal. And if they find out that you can demonstrate that it's more likely than not that you will be persecuted on account of race, religion, nationality, membership in a particular social group, or political opinion upon removal to that country, then the judge has no choice but to grant you withholding of removal. It comes with a work permit only. Okay, it's pretty it's limited in a way because the beneficiary does not benefit from it. You cannot bring your family members here based on withholding of removal, but you can stay here and have a work permit until you find another alternative of adjusting status on your own, right? Then you can go back to court and ask that the case get terminated so that you can adjust status. Let's say you get married or you have a child that turned 21. But when it comes to employment-based, unfortunately, it's not gonna work unless you have a parent or a spouse who's a lawful permanent resident or a U.S. citizen and ask for a waiver and go back home, which is kind of complicated in a sense of withholding of removal. But let's stay with the concept of withholding of removal. Remember, when a person is in court, right, and they apply for asylum as a defense, maybe they had an affirmative asylum case with USCIS, they didn't succeed, the case gets referred to court, and now asylum took another turn. It became a defensive type of relief. So the application for asylum is also the application of withholding of removal, provided that you check mark, right, that place that says I'm also applying for withholding of removal, right? Or you're just applying on your own terms for withholding of removal in court because there's really no deadline for it. So what's gonna happen is this: if you establish well-founded fear of past persecution, or you establish well-founded fear of future persecution, but still because of negative factors and discretionary measures, the judge decided not to grant you asylum, the fact that you were able to establish either the well-founded fear of past persecution or the well-founded fear of future persecution, the assumption is you are entitled to withholding of removal. Now your withholding of removal case become much easier, right? But in absence of you establishing all that, you fail to establish past persecution, you fail to establish future persecution, Can you still claim withholding of removal? The answer is yes. You can still claim withholding of removal. What can you show? How do you claim it? Number one, the regulation states that the applicant, you as a respondent in court, you are not required to demonstrate that you will be singled out for persecution if the immigration judge finds that the applicant established that there is the only thing, right, the applicant must establish is that the applicant can establish that there exists in the country a pattern or a practice of persecution of a group of persons similarly situated to the applicant, okay, on the ground that the applicant fears future persecution, and the applicant established that based on his or inclusion in an identification with that group of persons, it's more likely than not that there is a threat to his life, freedom upon return to the country. Let me explain that. For example, if you're claiming that I will be persecuted based on my faith, based on religion, let's say you are Muslim and the country where you're claiming persecution from as a majority Christian faith type of country. If you claim that you'll be persecuted based on your faith, when it comes to withholding of removal, you are not required to show that only you can be persecuted. The fact that you can show similarly situated people being persecuted based on their religion. For example, if you show that a lot of Muslims in that country get persecuted based on being Muslim, based on religion, based on faith, then you have proven that most likely your life and freedom is threatened upon return to that country. As simple as that. But remember that the standard here is a little bit higher because 50%, 51%, you have to show that more likely than not, you will be persecuted. You don't have to show that only you can be persecuted, that you'll be singled out. You have to have a lot of evidence. No, you just have to demonstrate it that similarly situated people in your position are persecuted in that country. How do you show it? Country report. Where do you find it? Stategovernment.gov. This country reports on all the situations going on in certain countries. The Department of State has reported those conditions of the country. You can just print it out. It's a authority that we use in court. It's acceptable as a form of authority, and point out that similarly situated people in your position will be persecuted. Therefore, most likely than not, I'll be persecuted. And this is a mandatory relief, and the judge has nothing else but to grant you withholding of removal. So if someone goes to court, fail to establish because of credibility issues, because of negative factors, they fail to establish their claim for asylum, and because of discretionary measure that the judge takes, but the person can still establish their claim of withholding of removal. My friend, it is important that you have a good representation because you cannot miss out on that chance. Only a judge can determine whether they can grant you withholding of removal or not the USCIS officer. Only a judge can determine that. So you have to be able to have proper documentations. You have to be able to have a good representation. If you need one, please call 202-751-2180. Email bijoux.ngwandaesq@gmail.com. Consultation fees apply as usual. Until next time, bye-bye.